Okay, this is Red Cedar Flats LLC versus Sears Roebuck and Company et al., docket number 19-741 CB. And this afternoon, I have 3 motions for summary disposition on the docket. I have and I don't know what order they were filed in, but I have the plaintiff's motion for summary disposition. I have defendant Sears' motion for summary disposition. And then I have the, as what we're gonna call the et al. Defendants, which is the easiest way to describe them, motion for summary disposition. And if I could start, please, just by having you all put your appearances on the record.
Good afternoon, Your Honor. Christopher Cataldo, appearing as co-counsel for the plaintiff in this case.
Good afternoon, Your Honor. Sam Chappelle, appearing as co-counsel for the plaintiff on this case.
Good afternoon, Your Honor. Maggie Mason, appearing on behalf of defendant Sears and Roebuck Company.
Good afternoon, Candace Phoenix, appearing on behalf of the et al. Defendants.
Okay, I don't know if the 3 or 4 of you have a preference on who goes first. I would like to hear them all argued, and then I'm going to rule on all of them at once from the bench. So I don't know if you want to go in order of who filed first, and I don't know who filed first. Or if you want to start with plaintiff.
Your Honor, I don't know who filed first. This is Christopher Cataldo. I'm going to address the issues on the Sears motion, both for and against. Mr. Chappelle is going to deal with what the court has called the et al. Issues. I know you've reviewed the materials, and so I'm going to try to get right to the heart of the issues. Issue 1, is this supposed limited warranty document part of the contract? And let me just say this, on its face, I would have to say that even if the document were part of the contract, my position would be it would have no impact. This document talks about defects in the material and workmanship of the refrigerator itself, which is not an issue in the case at all. No one's claiming there was anything wrong with the refrigerator. The issue is that during the installation, whoever performed the installation, and we believe it was one of the subcontractors for Sears, didn't connect the water hose properly to the valve. It came off and water leaked. There's nothing wrong with the refrigerator itself. There's nothing wrong with the hose itself. It just was the manner in which it was connected was defective, and that resulted in property damage. But the point being, Your Honor, is that this document we've shown by affidavit was not provided to the plaintiff when the refrigerator and other appliances were purchased. It was not part of the quote. And this document showed up not even in part of the case, but for the first time in early October as a supplemental disclosure after discovery had already closed in the case. And there is no explanation in the 2 briefs that Sears has filed. They've made a statement that to the effect that this document was part of the contract. Where, how, that's never explained, nor is there any affidavit or evidence before the court that would allow the court to make that determination. And we have submitted 2 affidavits which indicate that this document was not provided. Sears quotes the testimony from Mr. Chappelle's deposition that says that he bought many appliances from Sears. Great. He never says, and I got this warranty at every time. He never says anything about the warranty. This document was something that wasn't known to us until the first week of October, and certainly wasn't known to us at the time of the deposition, and it certainly wasn't known to us at the time that refrigerators were and other appliances were purchased. So that's our explanation with respect to that issue, Your Honor. There's nothing in the record that would enable the court to make any determination other than it was not part of the contract. Second issue, Your Honor, whether or not, does the economic loss doctrine apply in this situation? And again, we're not talking about a situation where there's any claim that there is a defect in the product. And obviously, if we were saying, hey, the refrigerator broke and the compressor didn't work. Clearly economic loss doctrine. If we were saying that because of the manner of the installation, they dropped it and the refrigerator broke, economic loss doctrine, no question about it. But that's not the issue here. Here, the issue is that Sears, they sever off from the contract the services portion, which is the installation. And they hire subcontractors to perform the services, which is the installation. And those services are performed in a negligent manner. They don't connect the hose to the wall, to the spigot in a proper manner. When they come onto our premises, it doesn't damage the goods, meaning the things we bought weren't defective. The hose isn't damaged, the refrigerator isn't damaged. It causes a water leak that causes itself damage in the premises. That's not covered by the economic loss doctrine. So our position would be we have both a remedy under the contract against Sears, but we would also have an alternative remedy in tort that is not precluded by the economic loss doctrine. So, Your Honor, as far as I'm aware, those are the main issues with respect to Sears. We think that they have not established anything that would entitle the court to dismiss the claims against them, and the court should make a determination on liability. We have not brought a motion on damages. The damage issue is not something that we have presented to the court at this juncture. It's only liability. And clearly the contract with Sears required them to do the installation. We know the installation that was done in a defective manner. There was water damage. And the question of what and how much damages result from that is not for the court today. So for those reasons, I would ask the court to grant our motion against Sears and deny the Sears motion as well.
Okay. Then Ms. Mason, did you want to be heard on that?
Yes, Your Honor, if I may.
And on your motion?
On my motion, and may I respond to Mr. Cataldo's comments as well?
Yes, like, we're just gonna put them all together.
Okay, all right, sounds good.
I know it's a little confusing. It was for me too, reading the briefs, but.
That's okay. We'll get through it. So plaintiff has Your Honor, plaintiff can't have it both ways. They can't have a cause of action and negligence asking for non-economic damages, and at the same time have a cause of action asking for economic damages based on the contract. This is a transaction in goods. It is governed by the Uniform Commercial Code. The plaintiff qualifies as the buyer, defendant Sears qualifies as the seller. This is absolutely a UCC case. The economic loss doctrine says that a negligence cause of action is barred when there is a contract in the sale of goods. Everything in this document indicates it's a sale in goods. Secondly, if we get to the breach of the UCC is going to apply to the breach of contract argument. Once again, it's a sale of goods. Commercial products under the Nieberger case, which is the #1 case that is the black letter law at this moment for economic loss versus torts allegations, is that commercial products, although requiring services, if the primary goal is to produce the goods, the primary of the goal is to acquire the goods, then it is a transaction in goods and is considered part of the economic loss doctrine, and the economic loss doctrine applies. Plaintiffs have not asked for any non-economic damages. Nobody was hurt. Nobody's claiming injury. Nobody's pain and suffering. We have purely contract cause of action. At no point have they asked for non-economic damages, ever. And while we're looking at whether or not the UCC applies, the UCC is very clear regarding express warranties, implied warranties of merchantability, and of particular purpose. When we look at these, they can absolutely be excluded under the Michigan Uniform Commercial Code. And Sears did exactly what it was supposed to. It expressly disclaimed them. It says that, oh boy, I lost my notes, that the sole and exclusive remedy for the plaintiff is limited by the warranty, and the sole remedy shall be to repair or replace. And it says very clearly, there's no liability for incidental or consequential damages. plaintiff is going to claim in their response, or they have claimed, that they had no notice of the warranty. Scott Chappelle, both in his recorded statement to auto owners, as well as his deposition, said that he has done business with Sears exclusively in the past, that he's done a significant number of business, and that that he has always looked to Sears to be the installer as well as the provider of the goods. Then we get to the actual contract, and the contract says that Sears or Kenmore or whomever, because there's some question as to whether there's privity, is required to provide the goods and to install the goods. So what we're looking at here is the contract actually anticipated the installation of the refrigerators. It says right on there to provide the goods and to install the goods. And that's exactly what Sears did. It appropriately delegated its duty to transport the goods and install the goods. And the warranty says that your exclusive remedy is limited to repair or replacement of the vehicle or of the refrigerator in 1 year. So looking at the contract, we have Blue Marble who did the installation, and the claim, according to Mr. Cataldo, is that it was improperly installed. Going back to the Nieberger case, once again, commercial product, when the contract is the primary goal is to procure a good, is governed under the UCC and governed by the economic loss doctrine. Under the UCC, my client effectively disclaimed the warranties. Whether or not the plaintiff had notice of the warranties, find it interesting that Mr. Chappelle testified that he exclusively worked for Sears, that he knew what to expect from Sears, and that he has an ongoing relationship from Sears, but he knew nothing about the warranty. Of the hundreds of appliances he purchased, he's never had a warranty claim. Not only that, the refrigerators were accepted at the time of delivery, and there was no objection to the refrigerators when they got there. And the Uniform Commercial Code says that additional terms to a contract, which warranty would be an additional term, because looking at the contract itself, it doesn't talk about the warranty, but additional terms become the basis of the bargain of the contract when in fact the goods are accepted and are not objected to. So there's no argument here that the goods were not accepted. There's no argument here that they objected to the refrigerators when they came in. And so the warranty in effect became the basis of the bargain. Nevertheless, the warranty was included with each and every appliance. As to why we did not have it earlier, Sears is in bankruptcy, as I'm sure everybody would know. No Sears employees even exist at this point, and getting that information was difficult. As soon as I received it on October 15th, all the parties had it as a supplement to my initial disclosures, but they didn't need it because Sears provides it with every appliance. Just as when you get your automobile, the warranty handbook, the owner's manual, it's in the glove box. Everything comes together. To look at Mr. Cataldo's argument, he says the limited warranty is not part of the contract and it has no impact because of materials, we're looking at the workmanship of the installation. That's not right. Look at the quote. Look at what plaintiffs claim is the contract. It says right on there that it includes installation. The contract included installation. And then looking at the warranty goes to workmanship, materials and workmanship of the product. It says right on there, materials and workmanship. So the contract included installation, and what plaintiffs are claiming is that there's a workmanship issue. So then we look at the warranty, and the warranty says that it's for materials, defects in materials or workmanship. And then it goes on to say that it does not cover goods that a non-authorized agent of Sears provided the work for. So in other words, if it's a non-authorized person, such as one of plaintiff's employees or contractors, then Sears is not going to provide coverage. However, this was Blue Marble is an authorized agent of Sears. Blue Marble, arguably, not necessarily agreeing or disagreeing with Ms. Phoenix's arguments, plaintiff claims was the installer. The installation was part of the contract. The installation is part of the warranty. The installation was completed, and the warranty clearly says that the only form of recovery is to replace or repair the refrigerator within 1 year's time. At no time was it requested that the refrigerator be replaced. At no time was it asked to be repaired. At no time was anything under the exclusive warranty and remedy asked for. Furthermore, it says very clearly on the warranty that incidental and consequential damages are not permitted. And the water damage that has only been claimed as economic, the economic damages of plaintiff that cause losses of rent are purely economic and are the only plausible consequential incidental damages that plaintiff might have had. Okay, and I think I covered all my issues. Sears requestfully requests that it grants its motion for a summary disposition, that this in fact was a transaction in goods pursuant to the Uniform Commercial Code, and that the warranty under the Uniform Commercial Code was effectively disclaimed and or limited. Thank you.
All right, thank you.
Very brief, Your Honor, if I may, just.
Go ahead.
Your Honor, Nyberger involved a situation where the goods themselves were defective. Here, no one's claimed there's anything wrong with the refrigerator. The refrigerators are fine. It was the services performed as we've discussed. And two, I've heard here now for the first time somehow that they're claiming this document, this refrigerator warranty, was provided to my client. Obviously, it was not an attachment to the quote. It was stapled to the quote. We would be having a different conversation right now. It wasn't. I just heard from counsel somehow they're making a statement that this document would have been provided to the buyer of the refrigerators. When, how, where, never been explained. And there's nothing in the record that would allow the court to make that determination. We've provided 2 affidavits that said that until the first week of October, we didn't have this document. And it may be true, may not be true, that Mr. Chappelle may have bought 1 million other refrigerators from Sears. The question is, I mean, he didn't say anything in his deposition saying I had a limited warranty on each of them. They never asked about a limited warranty. The issue never came up and it wasn't talked about in his deposition. And the existence of this document wasn't even known of it as part of this case at that time. So again, Your Honor, there's been nothing, there's no affidavit, there's nothing that would show that this warranty document, even if it applied, was part of the contract.
All right, thank you. Ms. Phoenix, you want to do the et al. Defendants, and then I'll go to Mr. Chappelle.
Sure, Your Honor. And this, you want me to be limited to the contract claim, or?
I just sort of wanted to do your
I can do my whole argument.
Yeah.
Perfect. Okay. Yes, Your Honor. I will just briefly comment on what they were just discussing. And essentially, my understanding is that Ms. Mason is saying that the warranty shows up with the goods, just like all of us, when we purchase any goods, we get the copy of the warranty when we purchase it. And I do want to point out for the court that in my brief, and I'm not sure if it appeared in counsel for Sears's brief, but there's reference to the timesheets of Dan Poxon. He's the one that actually stripped these refrigerators down and pulled the packaging off. So it would be Mr. Dan Poxon who would have seen any warranty that came with the refrigerators for what that's worth. But the main gist of our MSD before the court, Your Honor, is basically pointing out to the court what plaintiffs haven't proven, and it is their burden of proof in this case, and that's why we believe we are entitled to summary disposition. When I looked at plaintiff's responsive brief to our MSD and their own MSD, they do not have anyone actually testify or put in their affidavits that the defendants installed these water lines, that they saw them install these water lines. It is purely speculation. They are guessing that because they wanted them to, or had an expectation that they would install the water lines, that they did. No, they don't even bother to take the time to talk about the fact that Dan Paxson admits in his own timesheets about all of, stripping the refrigerators after the et al. Defendants leave, working on Sears installations when they are not there. There's no peep about all of the work that Dan Paxson was doing to install the refrigerators. And there's also no discussion about the fact that the refrigerators were actually installed earlier in May. This arises out of a May 23rd incident where the refrigerators have apparently already been put in, and there's this argument that there were water lines that weren't attached yet, and speculation that of the people who were present around the time of this incident, this water leak happened, that the et al. Defendants are the ones that are going to be on the hook. There's no investigator outside of plaintiff's own employees to have proven that this was actually the cause of the water leak. There's no investigator that says, or no person that says that they witnessed the water lines being installed. Scott Chappelle doesn't say it in his affidavit. Kyle Briggs, Ron Calhoun, Dan Paxson, none of them say in their affidavits that they saw the defendants actually installing any water lines. That is like the basis by which they're beginning this lawsuit, and they haven't even been able to prove that. I could see it if there was affidavits in the record before the court right now that said the defendants were there, we witnessed them installing the water lines, and then before I left for the end of the day, I saw that these things were loose and water was going everywhere. That's not what happened. All they say is we opened the property. They don't say anything about what Dan Paxson was doing that day inside the property. And what's most important is they do not talk about witnessing the et al. Defendants taking any action which could be considered negligent. The bottom line is there's not a statement from any party. There's no witnesses that can say to this court or to any jury that they saw defendants acting outside of their work order and installing water lines, which they weren't even set to do that day. We talk at great length in our motion, Your Honor, about the actual work orders and the fact that they are acting according to their work orders, and the fact that this punch list, which is the main thing that plaintiff relies on, is a punch list that asks for them to work on refrigerators in the different units. Yet the work order says to install laundry centers. And that is what they did. There's no question about the fact that there's laundry centers on the work orders. There was a attempt to overthrow the affidavit of Mike Blakely. Mike Blakely, there is a representative of FSA, and it was also identified as formerly known as FSA Network. Representatives of that company and all the et al. Defendants were identified at subparagraph 3 of our witness list filed in May, and then he was specifically noted as being the chosen representative in our trial witness list filed in October. Plaintiff had no issues with the way that we set that up with representatives of and then special selections prior to the trial until they got the affidavit, and now they're claiming it's a problem. We understand, Your Honor, that plaintiff is basically saying that they anticipated or they hoped or they expected water lines to be installed. That is completely different than the water lines were actually installed, and we have some proof of that. And on top of that, a step further, that they were installed in a negligent manner, that they simply have not produced any evidence in this case. And that's because they can't, because it doesn't exist. And the affidavit of Mike Blakely makes clear that, on the contrary, he is actually there. And he's actually witnessing the installations, and nobody's installing any water lines. They are all installing laundry centers. And there's been no claim that the laundry centers which were installed that day caused any leak or caused any trouble. So the piece that I guess we add to this argument, Your Honor, is even if this court said, well, they may be speculating, but there's something there for this water line. And even if the court did want to entertain that argument, which obviously we do not believe is properly before the court and the burden of proof has not been met, you would still have to prove that there was something more as far as damages. Plaintiff had coverage for this loss. In Scott Chappelle's recorded statement to auto owners, he says, well, it was a toss-up between whether or not I filed an insurance claim or, tried to sue them for what I believe they did wrong. And yet he just did both, which doesn't really make any sense because he admits in this case, throughout this case, nobody questions that they had a claim with auto owners. Auto owners honored the claim, covered them for their loss, and then they just decided to come with any balance to us, as opposed to going to auto owners for any balance that may exist on their alleged claim. And then lastly, Your Honor, they brought up these lost rents. Although Mr. Cataldo pointed out that in their brief, they didn't mention damages, we certainly brought an MSD on the issue of damages. And that has been our biggest issue with this case from the very beginning. Even if they could prove that we did install water lines instead of laundry centers and we did install them negligently, which they can't, they still have to prove that they actually have some damages suffered. So they said, well, it's these lost rents that we came up with on our own. And when we asked them specifically for some kind of a broken lease or an affidavit from someone who was going to rent it and then backed out, or any proof that they actually had lost rents, they turned up with nothing. And they sent us a current rent roll that shows that some of their nominee companies are renting space in the property. That doesn't show that they actually have damages or lost rents. And what doesn't make sense as well, Your Honor, and which also debunks the argument and results in summary disposition in favor of the defendants on damages, is that we went ahead and contacted Meridian Township and we pulled all the certificates of occupancy. And that was Scott Chappelle's big thing, saying, oh, this delayed our certificate of occupancy and we couldn't get it, and that's why we couldn't rent it out. Yet the certificate of occupancy for this particular building was actually granted to them before the other buildings on the property, which they claimed were fine and didn't have any issues. So there's absolutely zero support for any damages in this case, even if they could prove that the adult defendants did anything which was negligent. For those reasons, Your Honor, we are asking for summary disposition in favor of the defendants.
Thank you. Mr. Chappelle?
Okay, I will try to address those points and also proceed with my argument. I'll try to keep it brief. Plaintiff's motion only concerns liability at this juncture, but I will address the damages as well. And the only relevant issue right now is who negligently installed the refrigerator in unit 302, which is the unit at issue. Now, the et al. Defendants claim that it was Dan Poxon who did it according to his timesheets, but we have an affidavit from Dan Poxon who claims that he did not install the water line. Moreover, we know that the refrigerator was installed on May 23rd, the day the alleged loss occurred. The refrigerator wasn't installed the day before on May 22nd. Ron Calhoun emailed a punch list containing a myriad of outstanding issues to Sears requesting further service, and among those issues was the refrigerator in unit 302 still needed to be installed. So the refrigerator was not installed in early May. It must have been installed at May 23rd. And a representative from Sears responded to this email and confirmed that 2 teams would be out the following day to address those issues. On May 23rd, Dan Poxon left the contractors into Unit 302 to install the appliances on May 23rd, but as evidenced by his timesheets. And everybody agrees here that Blue Marble was the installing party. We have the services agreement between FSA and Blue Marble. We also have Sears admitting as such in their brief. And for the sake of clarity, each apartment unit has a water line connection, and each water line connection has a valve to turn the water on or off. The leak was the result of the refrigerator water line not being properly secured to the water line connection. And when the water was turned on, the resulting pressure caused the hose to disconnect and flood the apartments. The point here is that connecting the water line to the connection point and turning the water valve is a deliberate and purposeful action. Therefore, someone had to have performed this installation on May 23rd because no one else worked in the apartments over that weekend. And the leak was discovered the following Tuesday on May 28th. It could have happened at any point over the weekend, which is what everybody needs to understand. It likely happened, it didn't have to happen on May 23rd. Whoever installed the water line, the pressure built up and popped off, and then it managed to flood five or so units over the weekend. So we think it happened earlier over the weekend. And again, plaintiff nor any of its employees or affiliates installed the water line. And the et al. Defendant's documentary evidence is insufficient to suggest otherwise. Again, Blue Marble states that because nobody actually saw them install the water line, then they couldn't have done it. But it's extremely unlikely that someone just walked off the street and installed plaintiff's refrigerator. I mean, Dan Poxon is maintenance supervisor. His job is to supervise other parties performing installation activities at the project. And he's already claimed that he did not install it. So who did? Obviously, Blue Marble, the installing party who was in the unit that day, must have. And they produce a work order that doesn't include installing the refrigerator line. But I mean, who's to say that someone didn't act outside this work order? And finally, this affidavit by this Mr. Blakely, allegedly an FSA employee, this was not disclosed. This witness was not disclosed in FSA's interrogatories, nor was it disclosed in their witness list. So plaintiff requests that this affidavit be disregarded by the court. And even if not, it's extremely vague. I mean, we don't know who Michael Blakely is speaking on behalf of. FSA, does he also speak on behalf of Blue Marble? He claims that he's seen other people moving around the premises, moving appliances, but it doesn't say that he witnessed anybody installing refrigerator lines. And it also says he inspected all of the units before he left, but as I mentioned, the leak didn't necessarily have to occur on May 23rd. It happened in between May 23rd and May 28th when we discovered the leak on May 28th. So for the purposes of this motion, plaintiff has produced sufficient documentary evidence that Blue Marble actually performed the installation, and there's no genuine issue of material fact that Blue Marble was negligent in installing the refrigerator water line because it failed to ensure that the water line was properly connected to the wall valve. Similarly, FSA was negligent in hiring an incompetent contractor and for failing to ensure that the installation was done correctly and safely. Moreover, any references to Dan Poxon's installation activities in his timesheets are just incidental to his role as a maintenance supervisor, and nowhere does it say that he was physically hooking up refrigerator water lines. Now, plaintiff may properly hold FSA and Blue Marble liable for their negligence under two theories. First, plaintiff may be considered the third-party beneficiary of the services agreement between FSA and Blue Marble under Michigan Statute 600-1405, since the services agreement between FSA and Blue Marble contemplated the rendering of delivery and installation services to plaintiff. Even though plaintiff's name does not appear on the services agreement, both parties performed under the contract for the direct benefit of plaintiff. But even if plaintiff is found not to be a third-party beneficiary under the services agreement and therefore not in privity with FSA or Blue Marble, the Boylan v. 58 LLC case cited in plaintiff's brief stands for the proposition that parties to a contract may be held liable to third parties if a separate and distinct duty arises in the performance of the contract. One of those separate and distinct duties is if these parties come onto private property to perform their contractual duties. They have a duty to avoid harming those foreseeably injured as a result of them undertaking their contractual duties. Moreover, the court recognized that another duty that could be raised is by creating a new hazard on the premises. So when Blue Marble comes onto the premises to install a refrigerator water line and doesn't tighten it, they have created a new hazard that subjected plaintiff's apartment to flooding, which is indeed what happened. And finally, I'm assuming everybody is familiar with the case and has read it in our brief, like Pamar's contract with South Lyon, the services agreement between FSA and Blue Marble specifically indicated that Blue Marble would remain liable for its own acts or omissions in the performance of its duties. And finally, addressing the damages claims, Scott Chappelle indicated in his deposition that installing the appliances was the last thing left to do before the C of O was obtained. And so the results of us getting the C of O in mid-June and instead of in mid-May was a result of this water damage. So for those reasons, plaintiff requests that this court grant its motion for summary disposition and denies the et al. Defendants' motion.
I'm not going to go around with rebuttal because this has been briefed a lot, and I'm going to just leave it at that. The first issue I'm going to address is the predominant issue that's in the et al. Defendants' motion for summary disposition under C10. And the motion and brief don't really say what counts of the plaintiff's complaint it pertains to, but I think it's fairly evident. As I go on, I'll explain what I mean by that. But the et al. Defendants say they didn't install the refrigerator water lines and that the plaintiff has zero proof to the contrary. I have to disagree with that. First, the quote itself includes installation of refrigerators. The defendants go on to say that Mr. Poxon's worksheets prove that he installed the appliances. I say that the worksheets in Exhibit H are inconclusive. The et al. Defendants say that on May 7th, if he, Mr. Poxon, was shipping materials from refrigerators, then it proves that no refrigerators were installed prior to that date. Well, I don't think we're sure about that because right after that in his work notes, he writes 3 units building 5,000. So was he only shipping material in those units? And which units were they? Also, the et al. Defendants were there on multiple dates, including the key date of May 23rd. So even if they didn't install any refrigerators prior to May 7th, it doesn't preclude installing them after that date. The et al. Defendants say that the worksheets show that Mr. Poxon was doing the installation. And again, I don't think we can be sure about that at all because he writes in his work notes, quote, address installation issues with Sears delivery, end quote. So is he talking about issues he's having with installation, doing it himself, or is he talking about issues with Sears installation? I guess we don't really know that, or if there's more information in that regard, no one's pointed it out. And then we have to remember too that the only refrigerator that's really an issue is the one in Unit 302. So even if the worksheets or any other evidence show that Mr. Poxon was installing some appliances, it doesn't necessarily show that he installed the refrigerator in Unit 302. So next, the defendants rely very heavily on their work orders, their own work orders that are in Exhibit G. But those are also not dispositive, contrary to the defendant's position. The et al. Defendants say that they show that the et al. Defendants were not installing refrigerators. And I seriously question that because it's not at all clear that they mean what the et al. Defendants say they mean. But even if they don't reflect installation, there is other evidence that does. And that takes us to the punch list. The punch list is the exhibit that pinpoints Unit 302. And the defendants say that the punch list was not to be addressed until May 28th, which was after the leak occurred. I don't see that either. Wednesday, May 22nd at 10:13 a.m., Ron Calhoun emails the Sears representative and says, quote, I misspoke yesterday that no units were complete. After my walk yesterday, I think I found one that was complete. Please find attached a list of items that need to be completed. I believe the list is fairly complete. Dan Poxon will be on site tomorrow to make sure that everything is completed before your teams leave, end quote. Response comes on the same date at 10:33 a.m. Quote, okay, thanks, Ron. There will be 2 teams out tomorrow along with carrier manager to get you wrapped up, end quote. And on the punch list that Ron Calhoun sent, he has listed install refrigerator for unit 302. And Mr. Calhoun verifies all of this timeline in his affidavit. Mr. Poxon's second supplemental affidavit says that he did not install the refrigerator in unit 302 prior to the leak occurring. But again, there is other evidence that could contradict that. Mr. Blakely's affidavit attempts to do that. It is vague, and again, like everything else here, it's just inconclusive. He says, while present, neither myself nor any of the team members installed any water lines on the refrigerators, nor were they requested to do so per the work orders. So that is vague, leaving aside for the moment that, you know, whether he's even a witness or not, I'll just give the all defendants the benefit of the doubt, and if that remains to be sorted out later, we'll sort that out later when we're arguing about witnesses. But as far as his affidavit goes, I assume he can't be in every unit at once, observing everything that's being done all at one time. So what does, quote, while present, end quote, actually mean? Also, we know that the work orders didn't include connecting the refrigerator in unit 302, but the punch list did. And the Sears rep acknowledged receipt of the punch list and said things would be, quote, wrapped up, end quote, the following day, the 23rd. So the best that can be said about Mr. Blakely's affidavit is that it only illustrates the genuine issue of fact in this case. Of course, the worst that can be said is that it's completely inadmissible, but like I said, I'm giving them the benefit of the doubt, and we'll sort that out later. There is evidence conflicting on both sides here. There is evidence to show that Sears, or that the et al. Defendants installed the water line to the refrigerator in unit 302. There is evidence to suggest that Mr. Paxson did the installation. I'm not in a position of saying, well, the plaintiff may be speculating, but maybe there's something there. I don't do that. I have to look for genuine issues of material fact. The plaintiff has real evidence, and the et al. Defendants have real evidence. The evidence conflicts. I know that in some respects, it shows where the plaintiff says, we didn't install the water line, and the et al. Defendants say they didn't install the water line. Someone must have, but I cannot say who wins in that situation. I don't call that. That's deciding an issue of fact, and that is not for me and not in a motion for summary disposition brought under C10. These are issues of fact. There are genuine issues of material fact as to whether the refrigerator was installed in unit 302 on May 23rd or some other date by the et al. Defendants or not. And those issues of fact require that I deny the et al. Defendants' motion for summary disposition. They do have a second issue, and I'll address that. That's the one about damages. They say that there's no evidence of a delayed certificate of occupancy causing lost rent. But I have to disagree with that also. The et al. Defendants say there was no delay with receiving the certificate of occupancy. But Scott Chappelle testified that when the leak occurred, they were in the process of getting the certificate of occupancy with nothing left to do but get the appliances in place. He said that the leak and renovation pushed the certificate of occupancy off almost 2 months, and it, quote, took down the whole building, end quote, because they could not show it to prospective tenants and they could not consequently lease it. He never claimed that any leases were broken or that they had a lease in place that was delayed. So it stands to reason that he wouldn't be able to produce any leases. His testimony explains what the theory of damages is. And his testimony that the certificate of occupancy was delayed by almost 2 months is supported by the certificate of occupancy being obtained in July. So I'm concluding that the damage claim is not deficient in the way the et al. Defendants say that it is. I will next turn to Sears' motion for summary disposition. First of all, it's labeled as a C8 motion. I am considering it as a C10 motion because it wasn't briefed as a C8 motion. The first issue that's raised, and I'm not sure it's really raised, the Sears defendant says the plaintiff has no expert to say that the refrigerator or the water line was defective. Again, I say that I'm not sure they're raising it because this entire argument is in Sears' brief in section 1 called introduction, and it's never mentioned at all under section 2, law and argument. So it's very difficult to assess issues in briefs when they're briefed in that way. You haven't really made it as an argument, you sort of stated it in your statement of facts. It's for that reason and others, all the briefing in this case was very difficult to deal with. But in any event, the plaintiff isn't claiming that the refrigerator or the refrigerator water line were defective. The plaintiff is claiming that the installation service was defective. And they have a witness, Ron Calhoun, who does not have to have expertise in refrigerator defects or water line defects, since that is not the claim here. It may have been at one time, but I think the plaintiff has indicated that they're abandoning any claim that it's defective. So that addresses that issue. The next issue that's raised in the Sears brief is that the plaintiff's negligence claim is barred by the economic loss doctrine. The plaintiff says this isn't so because its claim is based on defective services, not a defective product. Even if this is about defective services, the economic loss doctrine still applies. The economic loss doctrine doesn't distinguish between products and services. It distinguishes between tort actions where consumers are injured and public safety is implicated, and actions involving the sale of goods where only economic expectations are implicated. The plaintiff says its claims of failure to hire competent subcontractors are cognizable tort claims. It is a cognizable tort claim when there's a physical harm to third persons, and that's exactly what takes it out of the reaches of the economic loss doctrine. But here in this case, there's no physical harm to anybody. There's a contract, and it's the plaintiff's economic expectations that have been harmed by alleged faulty installation. There is no legally cognizable tort claim because the economic loss doctrine forecloses such a claim. The Sears defendant also argues that there is a limited warranty in this case, which not only limits remedies, but also has a 1-year requirement. There is absolutely no evidence to show that the plaintiff ever received the limited warranty, or that the limited warranty was ever sent with the appliances, or ever became a part of this contract, or that the plaintiff ever even knew of its existence. The affidavits confirm that, but the defendant, the Sears defendant, points to Mr. Chappelle's testimony about the number of appliances that they've purchased from Sears over the years. I really don't think it matters how many appliances they purchased from Sears over the years. There is still absolutely no evidence that a limited warranty accompanied this contract, accompanied the appliances, or that plaintiff ever knew about it. Then there's this argument about, well, it became the basis of the bargain under the Uniform Commercial Code. And that's where, again, the briefing was very problematic for me in this case, because it's really not helpful to recite 3 pages of the Uniform Commercial Code verbatim and not follow it with any analysis or any application of that law to the facts of this case. I will say, however, that under the heading in the brief for Sears about the basis of the bargain, they cite some sections of the Uniform Commercial Code. And the first one, they have bolded an affirmation of fact or promise made by the seller to the buyer which relates to the goods and becomes part of the basis of the bargain creates an express warranty. Well, but that's just the issue here. There was no such promise made. And we're not talking about an express warranty. We're talking about a limitation on the warranty. So I don't find that that section has any applicability here. And then they cite MCL 440.2207. That section of the Uniform Commercial Code is about the initial formation of the original contract. It is not about if you accept goods that somehow you've agreed to something that you never knew about and never agreed to. It doesn't mean that at all. It's talking about the formation of the contract and the terms that go into it. So I don't think that's applicable at all either. The limited warranty, there's no evidence to show that the limited warranty applies in this case. I am, again, I'll say, totally confused by the large sections of Sears' brief where the UCC is directly quoted for several pages, but there's no argument or analysis or application of the law to the facts of this case. And that is the attorney's job. It's not the role of the court to read the UCC and then make your argument for you. Finally, the plaintiff has responded to Sears' brief saying that it has stated a viable claim for breach of contract, and it has, but I didn't even see that as an argument in Sears' brief, so it's only further confused the whole issue here. I've addressed the issues that I consider to be properly raised and briefed by Sears. I'm granting summary disposition to Sears as to any negligence claim against Sears, but everything else in Sears' motion is denied. And that takes me to the plaintiff's motion for summary disposition. The plaintiff asks for summary disposition on count 1, which is this breach of contract claim against Sears, and says that first, Sears had a contractual duty to deliver and install plaintiff's appliances in a diligent and reasonably skillful workmanlike manner, and that the warranty disclaimer does not apply. Well, Sears hasn't denied a duty as far as I can tell, and I've already addressed the warranty disclaimer, finding that it does not apply. But Sears doesn't raise any of the factual issues about who installed the water line to the refrigerator in Unit 302. So that's not part of Sears' response to the plaintiff's motion or Sears' motion for summary disposition. But the plaintiff is asking for summary disposition on the breach of contract claim against Sears. I can't rule that there is a factual dispute with respect to the et al. Defendants and then ignore it when addressing the plaintiff's motion just because Sears didn't raise it. So in the interest of a legally and logically consistent outcome here, I have to deny the plaintiff's motion as to count 1 breach of contract against Sears, because although Sears has a duty that's described by the plaintiff and refuted by no one, there is a factual dispute as to whether that duty was breached. The other counts in the plaintiff's motion for summary disposition pertain only to the et al. Defendants, so I have to circle back to them. They responded to the plaintiff's motion by reasserting the claim that there's zero proof that they installed the water lines on the refrigerators. I've already addressed that and concluded that that is an issue of fact, a genuine issue of material fact. Then the et al. Defendants state in one sentence that Sears has outlined why plaintiff is limited to contract remedies and cannot make any negligence claims against, quote, these defendants, end quote, in light of the economic loss doctrine. I do agree, as I've already said, with the economic loss doctrine argument that Sears put forth, but I'm not aware that Sears was representing the et al. Defendants when it made that argument. The et al. Defendants have said that they concur in Sears' motion, but that only means that they agree that Sears should be granted summary disposition. It doesn't allow the et al. Defendants to just magically apply all Sears arguments to separate claims that are made only against the et al. Defendants. But to the extent that the et al. Defendants are claiming in response to the plaintiff's motion that the economic loss doctrine precludes the negligence claims against Forward Air in count 3 and against Blue Marble in count 4, and to the extent that the et al. Defendants in response to the plaintiff's motion are requesting judgment in their favor under I-2 on counts 3 and 4, which they did not expressly ask for, then I am granting that. Then the et al. Defendants say without any legal authority that the plaintiff has no standing to sue them. Standing through me, there's no cross motion under C5 or C8 where the et al. Defendants say all claims against them should be dismissed because the plaintiff lacks standing. What the plaintiff has done is to bring third-party beneficiary claims. These are like breach of contract claims against the et al. Defendants based on MCL 600.1405. Quote, a promise shall be construed to have been made for the benefit of a person whenever the promisor of said promise has undertaken to give or to do or refrain from doing something directly to or for said person, end quote. The et al. Defendants have not addressed the statutory basis of those claims at all. Of course, the et al. Defendants have addressed the factual basis of those claims, and that's the genuine issue of material fact that I've already found, and it's the reason why I'm denying the plaintiff's motion for summary disposition as to counts 6 and 7, which are the third-party beneficiary liability claims against Forward Air and Blue Marble, because there's genuine issues of material fact as to whether the promise that the plaintiff claims to be the third-party beneficiary of was in fact breached. So to sum up, it's the negligence claims that are disposed of in these motions, and all the other claims have the same underlying genuine issue of material fact about who installed the water line, which goes directly to whether any promise, contract, duty, etc. was breached. So I cannot resolve those issues when there is a disputed issue of material fact. Who wants to do an order?
Oh, Your Honor, I can certainly take a stab at it and pass it around and see if we can stipulate.
You just have to say for the reasons stated on the record, but of course it has to spell out the counts and the motions.
Right, and I did have that 3 and 4 summary disposition was granted in favor of the et al. Defendants, and on count 6 and 7, plaintiff's motion for summary disposition was denied because there's genuine issues of material fact. I believe that was
Correct.
the same for counts 1 and 2.
Correct.
Okay, perfect.
Well, actually, I don't know what count 2 is. I didn't have count 2. Plaintiff very specifically said they were bringing their motion on count 1, 3, 4, 6, and 7.
Okay, I guess I better look and see what count 2 is.
Okay, I have attorneys waiting on the next hearing though, so thank you.
Thank you, Your Honor.
Thanks so much,
Thank
Your
you,
Honor.
Your Honor.
We'll circulate a stipulated order.
Thank you.